Hey everyone, Happy New Year. Harry here to talk about the Mar-A-Lago case before Judge Eileen Cannon. Remember that one? And latest from Donald Trump about advice of counsel. Now, the United States, Jack Smith has made this move in both the Mar-a-Lago case, where Trump always has a more hospitable reception, and the January 6th case. He's now, has Trump answered Smith's move, but only in Mar-a-Lago. He's still, doesn't want to do anything to even suggest he's advancing the ball in the January 6th case, which, where he wants the stay to last as long as possible. But it's the same, and you can expect it in January 6th as well. All right, so Jack Smith did a really clever thing that I think is sensible. But of course, clever plus sensible doesn't equal success in Judge Cannon's courtroom. But here's the deal: advice of counsel is a really stringent defense. You can't just say, my lawyer made me do it. There are real rules of precursor showings you've got to make before you're entitled to even put the idea in front of the jury. And that includes showing first that you disclosed and the lawyer had all relevant facts. And second, you relied on what the lawyer told you. So an opinion where a lawyer hasn't been told, oh yeah, and by the way, I did hide the money in the safe. That wouldn't work. It's got to be based on everything, and you have to truly believe it in good faith. It's not enough that that a lawyer even tells it to you, and that principle that you have to actually believe in good faith that what the lawyer telling you, that opinion is solid, is huge here, because we know that Trump got multiple opinions. All of the adults in the room told him again and again he couldn't do some of these things. But he, at the end, listened to handpicked and, in many cases, recently hired crackpot lawyers. Is the team crazy? And is that in good faith when thanks goodbye to six lawyers consecutively until you get the seventh, a John Eastman or whatever, or Sidney Powell, to say something crazy? I don't think so. I think you're rather just going through this elaborate process to get a lawyer to say something that you don't in good faith, or don't reasonably in good faith believe. All right, so what Jack Smith wants to do is says, we get to have a lot of information in order to make sure that, and challenge whether Trump has established these preliminary requirements. So we want all his communications with, and this is also a right that you have, because maybe the lawyer who gave you the advice kind of elsewhere said in a different lawyerly way, now I'm not saying X, but you can think about Y. So you want all the communications with that lawyer, and you want all communications, and you're entitled to all communications from lawyers that contradict that opinion. That goes to your good faith. And what Smith wants to do is have plenty of time to get those opinions, put Trump on the stand if necessary, not the same as testifying in front of a jury, just preliminarily before Judge Cannon, also Judge Chutkin, when this same issue plays out, and establish what all the other opinions were, who these lawyers were, and be in a position to argue to Cannon, and this is the real nub of the matter, before the trial starts, that he doesn't fit the prerequisites, and he's not entitled to raise an advice of counsel defense, And if he even begins to do it in trial in front of a jury, it's improper. Trump, on the other hand, wants to pull a fast one. I've been involved with defendants who like to try to do this. It's maybe par for the course, but you want to avoid all those requirements, but just insinuate in front of the jury, just get before them that a lawyer told you this without going through all the requirements. So you can either argue it, or so when they're back in the jury room, they said, but yeah, but didn't he say that John Eastman, and he is, by the way, talking about John Eastman, who he's describing as, the super eminent John Eastman, who may or may not have been disbarred by the time we get to this point. He's in very hot water, not just criminally, but with bar authorities. But they hope a jury will, get some hints on this and maybe use it to cut Trump a break, etc. So it's an important skirmish to have in advance, and that's what Smith wants to do. He says we need a couple months before trial all this information. We may have follow-up, depositions to conduct and the like. So Trump now today files a motion in front of Judge Cannon. It'll be really interesting if she permits it, because he doesn't really give much. He just says, oh, we haven't gotten all our discovery from the United States, and it's just not fair, and I shouldn't be, at least for now, required to give over all this information. But, the only reason not to give it over is so they couldn't test the bona fides of the advice of counsel defense. So he's got a brief, that makes basically a series of inapplicable points. They haven't given us enough discovery on their own. But also, and this is an important point, this is totally in court's discretion whether or not to force the, in theory, you could be in the middle of trial, and the defendant could say, I want to proffer an advice of counsel defense, and the jury can be excused from the room, and very quickly and summarily you try to maybe put the lawyer on the stand, or put Trump on the stand again just in front of the judge. And it's done in a slapdash way. But a lot of courts, and they present them chapter and verse, have basically said that, have denied government motions to get all the information up front. So that one thing they're able to say is, look at all these times courts haven't done it, and there's only a few where courts have. Smith addressed that in the motion to get the stuff early, and basically gave the reasons why it really matters here, and why there's reason to think that Trump would play it fast and loose, and in particular try to shield the judge, or the judge is the one who will say in the first instance, can he present an advice of counsel defense, from the whole litany of the grown-up lawyers who told him not to, and the like. So he wants to try to do it by sort of ambush in trial, in a way that he can bob and weave and not have to both give over the information and not have a really full test of his right to an advice of counsel defense. Just sort of slam it down quickly, get the judge to say, and this is what happens in criminal trials anyway, and I think it's especially what happens in criminal trials with Eileen Cannon, that you call, you sort of reduce the strike zone to call him for the defense on the thinking that, hey, if he's convicted, if he's acquitted and he wins because of what I've done, it doesn't matter, because the government is not going to be able to appeal. If he's convicted, I don't want to be in a position where I made a mistake, so I should sort of lean into a pro-defense stance, because he's not going to be able to bring up a claim, oh, you were too nice to me. And this might be the one with an inexperienced and possibly Trump partisan judge to just say, no, we'll do it as normal. But the right answer here really is to give over this information, give it early, let the United States test it. There's every reason to think that he's not entitled to raise an advice of counsel defense, not to say that Judge Cannon won't let him. So now we're sort of set up for a hearing where the arguments will be about whether Trump should be ordered to produce the information necessary for the United States to challenge his advice of counsel defense well in advance, a couple months in advance of trial. And that's what comes next. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.